Well, good afternoon. Welcome to our third session of the COVID-19 resources for our community's webinar. I'm Sandy Ratliff. I'm with Virginia Community Capital, and I am happy to be a partner with Virginia Department of Housing, Community Development, and the Virginia Small Business. Our presentation. I wanted to let you know that we have muted everyone in order to keep our webinar flowing and stay within the 1 hour goal. But please don't hesitate to ask questions on your screen. You should have a Q&A section or an opportunity to chat. And so what we will do is we will address those at the end of the session. We are excited to have Williams Mullen join us today to lead this webinar. If you're not familiar with Williams Mullen, they are a full-service law firm serving the Mid-Atlantic and beyond. They will provide practical advice on how to take advantage of the offerings, including the Small Business Administration, Economic Injury Disaster Loans, or as many refer to as the EIDLs, and the Paycheck Protection Program, which is, again, people refer to it as the PPP. We will also discuss the Families First Coronavirus Response Act and the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act, and what it means to employers. And before I turn it over to our guests, I would like to take this moment to, again, thank you, and I want to give a little brief introduction of each. Brydon DeWitt is a partner with Williams Mullen. His practice focuses on all areas of employee benefits law, including qualified pension plans, welfare plans, Affordable Care Act compliance, HIPAA health information privacy and security, stock-based compensation, and benefits issues arising in mergers and acquisitions. He is the host of the Williams Mullen's Benefits Companion podcast, which provides employers with critical information regarding their benefits plans. Brydon has been immersed in the government's response to the COVID-19, including analyzing the impact of the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act, and the Families First Coronavirus Response Act on all employers. Second up is Charlie Alvis. He is an associate in Williams Mullen's finance and real estate practice. He assists clients on all aspects of commercial real estate transaction and general corporate matters, including complex financings. Charlie has been actively reviewing and preparing legal updates on potential financing options for small businesses impacted by the COVID-19 emergency, including the Small Business Administration's EIDL and the PPP. Third is Yiorgos Koliopoulos, is an associate in Williams Mullen's labor, employment, and immigration practice. He advises clients on a broad range of labor, employment matters, and helps develop and manage company policies, employment contracts, employment handbooks, terminations, and reduction in force plans, and executive employment agreements. As he is well-versed in the Fair Labor Standards Act and the requirements of the Family Medical Leave Act, he is actively engaged in counseling clients on the myriad of employment-related questions that have surfaced due to the recent legislation, including the Families First Coronavirus Response Act. Thank you, gentlemen, for spending your lunch hour with us and to share your knowledge. This has been a difficult time for many. And I will turn this over to Brydon.
Okay, let's see. So George, I think you can go ahead and start off. We'll go through these slides, and I'll advance to the first slide.
Hello, everyone. Thank you for your time today. My name is Yiorgos Koliopoulos, as Sandy said. As many of you know now, Congress has rushed to pass a bunch of laws, and interestingly, they're also passing guidance that is trying to clarify a lot of these laws because a bunch of questions remained unanswered. With that said, this is a very high-level, broad overview of the laws. If you have any more specific questions, please put them in the Q&A and we'll do our best to answer them for you. So as you know, under the FFCRA, Congress passed two different types of leave. The first is I would put in the category of an expanded family medical leave. And then the second I would put in the category of the paid sick leave. We're going to discuss both of those here. Here in this first slide, if an employee's child or school closes down, or if their child care provider, is unable to care for the child, the employee is entitled to up to 12 weeks of paid leave to care for the child at a rate of 2/3 their regular hourly rate. This is capped at $200 a day and $12,000 in the aggregate. The leave is based on the hours the employee would otherwise be scheduled to work. All right, Brydon, let's go to the next slide. So another triggering event for leave is if the employee is under quarantine or seeking diagnosis. Now, if the employee is seeking leave for medical reasons related to the employee himself or herself, then the employee is entitled to up to 80 hours leave, capped at $511 per day. This is based on their full-time amount of work. So how many out? This is not capped at 2/3. That's a very important distinction to make. So to summarize, the employee is entitled to paid leave at 100% of their regular rate of pay. For full-time employees, it can be up to 40 hours a week. But for part-time employees, you want to pay them their average based on the average amount of hours that they work over a 2-week period. If the employee is caring for an individual, a family member under quarantine, then the employee you calculate it based on the same amount of time, about 2 weeks. Full-time employees capped at 80 hours. Part-time employees, it's based on the average amount worked over a 2-week period, but this is at 2/3 of the employee's regular rate of pay. So I would break it down two different ways. Employees caring for themselves or seeking a medical diagnosis because of COVID-19, they get their full rate of pay. Caring for an individual, 2/3 their rate of pay. All right, going on to the next slide. Brydon's going to talk about the tax credits.
So these new paid leave requirements are basically paid by the federal government through refundable tax credits. So employers that are required to provide this leave, and again, this is employers that have fewer than 500 employees who are required to provide this leave, can offset their FICA tax obligation, the employer portion of FICA taxes, by the amount of the qualified leave that they were required to pay. The way you claim this is when you file your Form 941, you can withhold the amount of qualified paid leave that you pay to employees and withhold that against all of the employment taxes that you'd otherwise be paying to the government. And I've had to read this several times to make sure it's right. You can offset your employer portion of FICA, the employee portion, and the federal income taxes withheld from employees. So the entire amount that you would deposit with the government with your Form 941 can be offset by the amount of Families First required paid leave that you pay to employees. And then if there's still an excess, so if the amount that you paid in leave exceeds the amount of your employment tax liability, you can file a Form 7200 and seek a refund. And the IRS is saying that within 2 weeks, they're going to process these refunds. So it's a refundable tax credit that offsets the amount of the paid leave that you were required to pay. The wages that you use for this includes includes group health plan expenses. So the cost of providing health coverage to the employees on leave is also included into the wages that you can claim for a credit. And you can use your COBRA rate that you use for determining the COBRA premium for group health plans. So it's the wages, the required paid leave, plus the cost allocable to each employee who was on leave for their group health plan. You can use the COBRA rate for that, and it offsets your employment tax liability. Okay, George.
All right, so moving on to talking about, again, the paid sick leave law and the expanded FMLA leave law. Can they be taken intermittently? If so, how does it look? Expanded FMLA leave, the employer can allow the employee to take the expanded FMLA leave intermittently. An example of this is the employee is teleworking, and the employer and the employee agree, what times, what times work best for you, based on your, when do you have to, for example, if there's two parents now or they're without a child care provider and the one employee has to care for the children in the morning and their spouse or partner takes care of the children in the afternoon, you can work with the employee in terms of what hours of the day are you going to be working, and you can base the leave on the hours of the day that they'll actually be working. Now, with the paid sick leave, we've had to read the law a couple times, but unless the employee is teleworking, paid sick leave for qualifying reasons related to COVID-19 must be taken in full day increments. And especially in the case where the employee is seeking a medical diagnosis or has received a diagnosis or is showing COVID-19 symptoms, it makes sense that they don't take this leave from the actual office intermittently. Interestingly enough, it comes out to about 2 weeks of paid sick leave, which it coincides with the quarantine period of what the experts have been saying. Quarantine yourself for 14 days, see if the side effects have subsided, the symptoms have subsided. Consistent with the expanded FMLA leave, though, an employer can agree to allow the employee to take the paid sick leave intermittently, even if they're not teleworking. Okay, but with the paid sick leave for the qualifying reasons related to COVID-19 still must be taken in full day increments, not broken up like the expanded FMLA where you can break it up in times of the day. All right, we can go to the next slide.
Yeah, and I'll just interject here. In the IRS FAQs, the rationale was that if it's not for the care of a child, the reason that the person is getting the leave is because they're sick or they're seeking a diagnosis or they have symptoms or they've been ordered to quarantine. And so they want you to stay home and away and out for the entire period until the reason for your quarantine or you recover from COVID-19, until that is over. They don't want you reporting to a work site. And so that's why intermittent leave isn't allowed for the reasons other than telework or care of a child.
Thank you, Brydon. And going on to the next slide. So the emergency paid sick leave is in effect at any time before December 31st, 2020. So the employee has that time until it's exhausted, assuming they take it or they have a qualifying reason to take it before December 31st, 2020. So, if it's, they lose the child care provider, but then find another one, they only use 5 days of the, they use 5 days of the leave, or, it's going to be hard to find a reason to where they break it up over 2 weeks, especially if they got sick. So if they got sick, it's unlikely that, they wouldn't exhaust the full 2 weeks at one shot. But if they find a reason to where it would not be exhausted, they have those remaining days. So let's say there's 5 days left, they would be able to use those before December 31st, 2020 for a qualifying reason. So it's important that you keep track of those in the employee's records. If the employees work for fewer than 30 calendar days for the company, if an employee who has worked fewer than 30 days immediately prior to the day the employee's leave would begin is not eligible for the expanded FMLA leave. However, the employee would be entitled to emergency sick pay at 2/3 of the employee's rate of pay for up to 80 hours for full-time employees, even if the employee is not working, even if the employee has not worked for 30 days for the employer. rehired employees, employee who has been laid off not earlier than March 1, has worked for the employer for at least 30 days.
I just need to turn off.
Oh, sorry. Am I too loud? Sorry. Employee has taken non-FFCRA expanded FMLA leave. An employee's maximum FMLA leave during a 12-month period is 12 weeks. The FFCRA expanded FMLA leave, so the expanded FMLA leave for the COVID-19 reasons, is reduced by the employee's other FMLA leave. So total would come out to 12 weeks. So the FFCRA 80 hours, 2 weeks emergency paid sick leave is not reduced by the FMLA leave. That's important. The amount of FMLA leave left does not reduce the emergency paid sick leave. And again, these laws apply to employers with 500 or fewer employees. Employers with 500 or more employees, employers with 500 or more employees, the employee is not entitled to paid leave under the FFCRA. The employer can still voluntarily provide the paid leave, but the tax credit's not available. And then in determining employee threshold numbers, the FMLA's integrative employer test kicks in, or the FLSA's joint employer test. Brydon, this is you.
So again, as George is saying, if the employer isn't subject to the FFCRA leave requirements, if the employer has over 500 employees, or if the leave is provided before April 1, when these requirements went into effect, to the extent that the leave is not required by the FFCRA, there is no tax credit. So you're free to do it pursuant to your own policies, your own sick pay policies and PTO policies, or new policies that you may be developed in anticipation of the crisis. But the tax credit only applies to leave that is required under the Act. And when you claim the credit for 4 years, you should retain documentation substantiating the need for the leave, why the employee in particular took the paid leave, why you paid the paid leave, why it qualified under the FFCRA for required paid leave. So you can provide the extra leave on your own, but you only get the tax credit for the leave required under the Act. Okay, George.
So again, if the employee is able to telework, FFCRA paid leave is not available. Employers can encourage or require employees to telework, but they can't. But again, the Equal Employment Opportunity Law single out. Make sure you're not singling people out based on, not that anyone would, on a protected characteristic, etc. Also, the FFCRA leave requirements do not apply once a work site is closed. So, common sense, if the employer is no longer in business, they have no employees to pay, employees can't get FFCRA leave from a business or a work site that no longer exists. Brydon, I think that's you on the next slide.
Okay. And so before I get to this topic, one of the things I had to come to grips with or understand early on was that the FFCRA leave, the expanded family medical leave, and the paid sick leave only applies to the extent that the employee was otherwise required to work. So again, if the work site is closed, if the employee is furloughed, if the employee's hours reduced, the FFCRA does not protect employees against those events, at least as far as the leave requirement goes. So the leave is calculated only based on the hours the employee is otherwise required to work. So if an employee was on furlough before April 1 or after April 1, the time the employee is on furlough does not count. They don't get leave for hours they would not otherwise be scheduled to work. So on this next slide, there's another tax credit for employers who keep employees on their payroll and continue to pay wages during the crisis. If an employer's operations are partially or fully suspended due to a government order, or if an employer's gross receipts for a calendar quarter in 2020 are reduced by 50% or more as compared to the same calendar quarter in 2019, then the employer can qualify for this employee retention tax credit. A full or partial suspension, an example of a partial suspension is if the governor ordered, as I believe the governor has through Executive Order 55 in Virginia, restaurants cannot have sit-down service inside of their restaurants, but they can provide carryout. That would be a partial suspension of operations due to a government order, and those employers will qualify for this credit. The 50% gross receipts, so even if your operations aren't suspended, but the employer experiences a reduction in gross receipts of 50% as compared to the same calendar quarter in 2019, then the credit for wages paid to employees during that period applies for the quarter in which the receipts dropped by 50%, and then continues until the first calendar quarter following the calendar quarter in which receipts are more than 80% of the 2019 calendar quarter. So let's say in the current quarter, receipts drop by 50%, and then in the next quarter, receipts are at 85%, and then the following quarter, in the fourth quarter, receipts are at 90%. In the current quarter and the second quarter, in that example, the employer could claim the credit. The credit for employers with over 100 employees is 50% of the wages paid to employees who are not performing services. So employees that the employer continues to pay wages to, but the employees are not performing services, then there's a credit of up to 50% of those wages, up to $10,000 per employee, in effect, $5,000. So you can take into account $10,000 of wages, you can take 50% of those wages paid. So it's $5,000 per employee. For employers with under 100 employees, the credit is based on all wages paid to all employees who are working and employees who are not performing services. And you claim this credit the same way you claim the paid leave credit with the Form 941, the Form 7200, offsetting this credit against the employment taxes that you otherwise would withhold or otherwise would pay with your Form 941. Okay, George.
So one of the nice things that the Act did was extend unemployment benefits to people who traditionally would not otherwise receive them, such as independent contractors, gig workers, self-employed. So these people, in addition to regular employees, would be entitled to unemployment benefits if they certify that A, he or she is unable to work due to an event that would qualify for FFCRA paid leave. 2, is unable to work because the employee cannot reach his or her place of work due to a COVID-19 quarantine, including a new hire who was scheduled to commence work, has become the breadwinner because the head of the household has died from COVID-19, is unable to work because his or her place of business closed due to COVID-19, and or has quit his or her job because of COVID-19. In Virginia, the current max for unemployment benefits is $378 a week, but eligible individuals can receive $600 a week in federal pandemic unemployment compensation. So that would be you could, in theory, get $378 plus the $600 in federal funding. However, eligible individuals receiving FFCRA paid COVID-19 under, one of the employers with 500 fewer employees, with under 500 employees, they're not eligible for federal pandemic unemployment compensation benefits. And then, as I said earlier, traditional employees who are laid off, terminated, furloughed, or who had a substantial reduction in their work hours receive traditional state unemployment compensation up to 39 weeks of COVID-19 federal pandemic unemployment compensation benefits. And then they can get, as I stated, the extra $600 in federal pandemic unemployment benefits. And it also eligible individuals who receive the FFCRA paid COVID-19 leave are not eligible for the federal pandemic unemployment compensation benefits. So next slide. I believe that's you, Brydon.
I've got it. Yep. So if you maintain a 401k plan, you have some decisions to make, and most likely your record keepers have been sending you questionnaires and information about some choices to make for your qualified retirement plans. First, there is a new in-service distribution opportunity for individuals who've been diagnosed with COVID-19 or SARS-CoV-2. I'll just refer to all of it as COVID-19, but just know there's another virus that I guess is related to COVID-19. But if you're diagnosed with COVID-19 or a spouse or dependent is diagnosed with COVID-19, or if the employee has experienced adverse financial consequences due to a layoff or a furlough, then the plan may allow the employee to take up to $100,000 of an in-service distribution from the plan. That distribution is treated as a rollover made within 60 days if the employee transfers the amount of the distribution back into a qualified plan within 3 years. And the taxes on the distribution are paid or assessed ratably over a 3-year period. So if the employee takes the money out, they put it back in, it's not a loan, there's not an interest component to this, but if they take the money out and then they return the money to the plan within 3 years, it's treated as if they received an eligible rollover distribution that was transferred to another plan within 60 days, and there would be no tax. If you want to do this, however, it is voluntary. The employer does not have to add this to your plan. This is something you can choose to do. Second, for qualifying individuals, the same individuals, those who've been diagnosed with COVID-19, spouse dependent diagnosed with COVID-19, or they have severe financial consequences due to COVID-19, their plan loans, they can increase, the limits on plan loans have increased from $50,000 to $100,000 and from 50% of the vested account balance to 100% of the account balance for those qualifying individuals. Whether you make that increase is voluntary, whether you want to do that in your plan. What isn't voluntary, however, as we are reading the statute, is that if a qualifying individual takes out a loan or has a loan outstanding, currently outstanding, then the due dates for payments on those loans are delayed by 1 year. And so that's something the plan will have to administratively handle to delay the repayment of the loans for a year. So there's a new distribution opportunity, in-service distribution opportunity up to $100,000, and an increase of plan loans up to 100% of an employee's account balance or $100,000. If you are dealing with qualified retirement plans back in the Great Recession, when I believe it was 2009, required minimum distributions were waived. That waiver is back. So employees who have if they reach age 70 and a half before January 1, 2020, they are required to receive required minimum distributions as of April 1. Those required minimum distributions are not required for 2020. If you have a defined benefit pension plan, there's a delay in the required minimum contributions that are supposed to be made under the plan. And then to the extent that these changes are adopted or required, the plan must be amended by the end of the 2020 plan year. By the end of the plan year, beginning on or after January 1, 2020, plan amendments have to be adopted. So there's an extended, this is longer than we normally would have to amend a plan for a discretionary change. But you have to make sure that if you adopt these changes now administratively, if you start allowing the in-service distributions or you increase the amount of the loans, that those changes are accurately documented in a plan amendment that's adopted by the end of the 2020 plan year. For group health plans, the legislation, the CARES Act and the Families First Act address group health plans. That diagnostic tests for COVID-19 are covered, required to be covered by group health plans with no cost sharing and no medical management. So no deductible, no copay. and also no pre-authorization or any medical management. COVID-19 diagnosis tests, specifically the ones listed on the slide here, are required to be covered. If and when we have a vaccine, the vaccine for COVID-19 will also be required to be covered under a group health plan. So these are changes to group health plans. It probably won't be anything that an employer has to do to their documents. The insurance carriers and TPAs will be making these changes to their summary booklets, to their certificates of coverage, and operationally will have to put these into place. If you maintain a high deductible health plan and allow employees to contribute to a health savings account, there was guidance issued by the IRS, I believe, last week that said that these changes, because again, you can't apply a deductible, you can't require a deductible, that these changes will not affect the plan's status as a high deductible health plan. So these changes are required of all group health plans. It won't affect your high deductible health plan status or employees' ability to make contributions to health savings accounts. Well, trying to get my cursor over here. And the CARES Act also added a provision that if employers pay employee student loans, either by paying the lender directly or reimbursing the employee for student loan repayments, that those repayments, employer-provided repayments, are not included in gross incomes. They're tax-free. Employers can provide tax-free assistance to employees with paying off student loans. Okay, and so Charles, I'll pass it over to you.
Thank you, Brydon. This is Charlie Alvis. Thank you all for being with us today. I'm going to talk about the two loan programs that were created under the CARES Act and that are being administered under the Small Business Administration. Sandy mentioned both of these earlier, the EIDL, the Economic Injury Disaster Loan Program, and the Paycheck Protection Program, the PPP. We prepared a comparison chart of these two programs when the CARES Act became law and put this up on our website, and we have updated it as of yesterday to account for some of the recent regulations and guidance that have come out. So I'll go through the chart, and I'll probably be spending a little more time on the right side of the chart, the PPP, because that program is a little more involved and honestly may be the one that more folks are interested in. And the other two caveats I'll say about this is that, as I mentioned, there are guidance and regulations are still coming out on these programs. So any of this, not all of this, but some of this could be subject to change. And as folks are finding out, these two programs were created under the Small Business Act, which already had lots of rules governing these types of loans. And those background rules are in effect for these two programs. And as folks are finding out, those rules can be kind of complicated. And so anyone who's looking at one of these loans has to keep those rules in mind. And as a result, everything has to be done on a case-by-case basis. So keeping that in mind, let's go ahead and talk about the two programs. The first three rows on this chart are sort of high-level comparison. The CARES Act gives $10 billion in appropriations for the EIDL program and $349 billion for the PPP. The EIDLs are direct loans from the Small Business Administration, direct loans from the government. The PPPs are loans that you get from a bank, and you have to apply through the bank for the PPP. With the EIDL, you apply through the SBA's website. They have an online application, and they review it. With the PPP, you apply using a form that the SBA has come out with, but you still apply through your bank, and they are the point of contact. The program dates run a little differently. The EIDL goes through the end of the year. The Paycheck Protection Program ends on June 30th. The other caveat there is the PPP is on a first-come, first-serve basis. There's been a lot of scrambling around for folks to try to get in. There has been talk of expanding this appropriation to make these funds available to more businesses. As of yesterday, that had not happened yet. So even though the deadline is June 30th, there's a lot of interest among small businesses that we're hearing to go ahead and get those applications in. So the general eligibility, this is an area where there's been a lot of attention. Slightly different for the two programs. Before the CARES Act, the eligibility, generally speaking, was you had to be a small business concern under the standard set out by the Small Business Administration. EIDLs were also available to private nonprofit organizations. Congress expanded the eligibility for these things, and you can see who's eligible there. I won't read the list out other than to note that it's the key expansion of this is that sole proprietors and independent contractors are now eligible for these loans, and any business up to 500 or fewer employees are eligible, even if their business does not satisfy the SBA size standard for the particular industry that they are in. We had a Q&A question about eligibility under EIDL, and the questioner referenced the Treasury Department's FAQs that they've put out. Those are only addressing the PPP program. So I would say to the person who asked that question not to rely on that for EIDLs, advice on EIDLs, and also to note that if you are looking at those FAQs, which are very helpful, note that they are updating those documents. They've made several updates. They're not really changing answers so far that I've seen that they've put on there, but they are adding new questions and clarifying points as things go along. So it's worth checking back to see what may have come out in recent days if you haven't taken a look at that lately. So another point on eligibility that will apply to both of these programs is the existing SBA rules on affiliated entities. If you are a business that has an investor and that investor also owns another company or has an interest in another company, it's possible that other company will be aggregated with yours for purposes of determining the number of employees that you have when determining whether you can qualify for either of these loan programs. So if you have they're complicated rules, and they may not apply to lots of small businesses, but if you are related to other businesses by common ownership or common management or investors, it's something to look at, and they can quickly become complicated and perhaps the main question in the analysis of whether one is eligible or not. The affiliation rules have not been changed for EIDL. There are some exceptions under the PPP program. This is for basically hotel and the hospitality industry, hotels, RV parks, food service businesses with 500 employees or less per location rather than throughout the entire business. Franchises that have a franchise identifier code under the SBA, you can look that up and find if you're a franchisee, you can see if your franchise is listed there. Businesses that receive financial assistance from a small business investment company, I think you'll know who you are if that applies to you. And they have also come out with a guidance on religious organizations. Religious organizations are entirely exempt from the affiliation rules under the theory that if that applied to religious organizations that are part of larger denominations or other organizational structures, many religious organizations would be entirely exempt. So the SBA has issued a regulation that says the affiliation rules don't apply to religious organizations for the PPP program. Last point before I move on is to say that the under EIDL, it's a very you don't have to provide lots of documentation. You don't have to provide a tax return. They will do it on a credit score alone. Okay, some other points on general applicability. This line on duplication is really about folks who may have received an EIDL in between January 31, 2020 and April 3rd, 2020. April 3rd was the day that the PPP program technically came online and became available to be applied for. This is a little bit of a technical point, but if you're in that situation, it's something that you should look into and follow up and make sure that you haven't done anything with your EIDL loans that would perhaps cause you problems if you want to apply for a PPP. In general, if you did get one, you can get a PPP, but you have to refinance the EIDL that you obtained within that period of time. Finally, ordinarily under these programs, an applicant for a loan must have no credit available elsewhere, and that includes looking at whether your investors have credit available elsewhere and things like that. They have waived that requirement under the CARES Act, so it's opens up these loans to other borrowers who wouldn't have otherwise qualified. Loan terms. The maximum loan amount for the EIDL is $2 million, and that applies across all of the affiliates that a business may have. There is a waiver that's mentioned there. If you're a major source of employment, that's a sort of an analysis that would have to be done under the SBA rules. For PPP, the max loan amount is 2.5 times your average monthly payroll from 2019, or $10 million, whichever is smaller. Average monthly payroll includes quite a few things. It's not simply salaries and wages paid. It includes things like group health insurance. There's a long list of costs that qualify. State and local employment taxes qualify. Federal employment taxes paid do not qualify. There's a list of these things you can look up, and it's important to make sure you calculate everything so you can get the loan in an amount that you do deserve. The emergency grant aspect of the EIDL is not something that exists under PPP, but when you apply for an EIDL, you're able to request up to $10,000 right away. And the idea is that the SBA will disperse that money to the applicant business within 3 days, even if the applicant's EIDL is ultimately not approved. So that's a great advantage to that. And even if your EIDL is approved, you don't have to repay the $10,000. That is just simply grant money. So that's a good thing for folks looking at that program. I think on the next slide, we'll see more information on the loan terms. I'll skip down to forgiveness for just a moment, because that's sort of the corollary in a way to the emergency grant under EIDL. The big benefit under the PPP is that certain costs or certain use of funds that you pay from your PPP loan proceeds within the first 8 weeks of receiving them will be forgiven if you do it within the terms of the program. The 8-week period begins on the day that the bank first disperses the money to you. That was clarified in the FAQs as recently as a day or two ago. It was not entirely clear when the 8 weeks started before that. Another thing that is important to keep in mind, and we had a question about whether you can pay for rent or utilities that you incurred, during March or April, or pay for future rent. I'm not entirely sure of the answer to that question, but one way to think about it is that they've come out in the regulations with a requirement that you have to allocate at least 75% of your forgiveness amount to payroll costs, rather than some of the other approved uses that you're able to get forgiveness for, such as mortgage interest, rent, and utility payments. So I think that the one way to think about that question is if you were to pay several months of future rent, you might run into the situation where you're going to exceed the 25% that you're able to allocate. towards forgiveness, and therefore it might not be advantageous to do that. But I'm not sure exactly of the answer to that question. The forgiven amount is not taxable income to the business. That's something that was made clear in the CARES Act itself. So the forgiveness is basically the big incentive for the program. There are reductions to the forgiveness amount under PPP if you don't maintain your workforce or your salary levels. The rules for the reduction are a little bit complicated, and I don't want to necessarily get into them in the short amount of time that we have. But generally speaking, if you keep your workforce employed, or at least you keep paying them, and you don't reduce their salaries below 25% of what they were paying in the last quarter before the crisis, then generally speaking, you're not going to be in danger of the reduction. As well as if you laid people off between, I believe it's February 15 and April 26, but you bring them back by June 30th, those reduction rules also do not apply. So those are out there and things to keep in mind when you're looking at the forgiveness. So to move up to the top rows on this sheet now, the term for the EIDL is 15 to 30 years. I'm not entirely sure how that's being calculated for borrowers, but that's generally the range. 2 years for the PPP. The interest rates are fixed. The EIDLs are 3 3/4 for for-profit businesses, and the PPP is 1% for all borrowers. The use of the proceeds for the EIDL, it's pretty much working capital. There are lots of not lots of rules, but there are rules about what you can and can't use it for in the SBA's background rules. But generally speaking, it's meant to meet your expenses and the obligations that you have that are coming due that you're not able to meet. With the PPP, it's quite a bit more limited. It's the payroll costs that I was mentioning earlier, mortgage interest, rent payments, utilities, and interest on other debt that you incurred prior to February 15, 2020. Collateral not required for PPP, personal guarantees not required for PPP. Those are required subject to certain, after you exceed a certain threshold for the EIDL. Payment deferral, not applicable to EIDL. You do get 6 months of payment deferral for the PPP. And so that's kind of the general terms there. The last slide, I believe, really is directed at banks. This is some information about the differences between what banks were obligated to do before under the 7A program versus now. I'm not entirely sure that that's of interest to the audience here, but that's really the best summary in a short amount of time for a fairly complicated program. And I hope that's been helpful to folks. I will try to take a look at the Q&As if there are any on this program. But that's kind of where we are. And I'll mention again, as I mentioned at the beginning, that the program is continuing to evolve and things are continuing to be clarified. So please stay tuned for further guidance.
Well, thank you. We do have a lot of questions that are wanting answered, and I'm just going to, at random, ask some of these, and hopefully we can get to all of them before in the next 10 minutes. One was regarding the regulator's reference that if you receive the PPP and the EIDL as well, that the PPP not forgiven would be used to refinance the EIDL. Can you explain this and also how the EIDL advance would play into this? There's a lot of confusion on the part of everyone on this, and they would really like to have that explained. And by the way, I understand that the cap for the EIDL today has been increased to $15,000.
That's I haven't seen that piece of news, but that's interesting. And George, feel free to jump in here too. George has been working on these issues with me as well. My understanding on the ability to get an EIDL and a PPP, there's what we understand is that there's nothing that prevents you from doing both. It's simply that if you did receive an EIDL within that window of time that I mentioned, January 31 to April 3rd, you will be required to refinance it with the PPP funds if you used it for payroll costs or other things that are described as approved uses for PPP funds. That's how the interim final rules, the regulations that came out, address that issue. And it's a good point in the question about the forgiveness amount. If you do get an advance, and let's say you get the full $10,000 advance, that amount is deducted from your forgiveness amount at the end of your PPP. So that's another thing to think about when you are looking at what you might be able to get forgiven if you had gotten the $10,000 advance and then later get the EIDL.
Okay. Now, there are areas in Virginia that do not have employers that employ more than 20 employees. Will you be talking about how the employer requests an exemption for the COVID-19 FMLA for employers with less than 20?
So they haven't, to my knowledge, they haven't issued any guidance clarifying exactly what constitutes an employer where complying with the FFCRA's paid leave requirements would cause them significant economic difficulty to the point where it would affect them being able to operate as a valid business concern. My only advice at the moment is to document everything, document how complying with these expenses, for example, why paying X amount of employees or paying X employee, the amounts required under the Act would cause you financial difficulty because when you do use that exception, or if you do have to use that exception, you definitely want to have your documentation ready to go to show why you should not have to comply.
Okay. Here's a different type of question. Would the retirement plan penalty waiver apply to individuals who were laid off for reasons not due to COVID, but having greater difficulty finding work due to the current environment in regards to employment?
Well, that was for me. So the person has to satisfy the definition of a qualifying individual for purposes of, I was about to pull up the statute, for purposes of the coronavirus related distributions that are now permitted under qualified retirement plans. And so the way the statute defines it is a person who experiences adverse financial consequences from quarantine, furlough, or layoff, or if the person operates or owns a business and the business is unable to is closed because, or a business the person operates or owns is closed because of the financial conditions around COVID-19. Can you repeat the question, the specific question though, about?
Would the retirement plan penalty waiver apply to individuals who were laid off for reasons not due to COVID, but having greater difficulty finding work due to the current environment?
No, that would not. That person would not be a qualifying individual for the in-service distribution.
Okay. Another question, there's been a lot of discussion in our community that if an employee gets state unemployment and the federal $600 a week, they will make more money than if they were working. This doesn't sound right. Is the $600 a cap or a flat amount?
To my knowledge, the $600, I believe, Brydon, correct me if I'm wrong, I think it's a flat amount. And I think they would get that in addition to the state unemployment. Now, that is I think that's a valid discussion to be having. I think that's a valid concern. But keep in mind that at least in Virginia, the employee still has to satisfy, many of the traditional unemployment, any of the reasons for which they are applying for the unemployment. Now, again, here they have to be tied to the COVID-19. So if the employee has an employer that's willing to work, or that has a job, it's a safe environment to the extent it can be made safe. And for example, I'm thinking of an essential business. The employee can't just quit to then go collect unemployment benefits. He still has to have one of the qualifying valid reasons. Now, is the VEC granting the benefits more liberally now? Yes, I believe they are. And could I see a scenario where the employee would get paid more through the state and the federal government unemployment programs? That is possible, given the volume, given how overwhelmed these governmental entities are right now trying to process all these claims. I could see that happening. And yeah, so to answer your question is I think that is a valid concern for employers. Now, I don't see a problem with reminding the employees that, if their job is in fact available, for example, I'm thinking of a teleworking employee, and they are not sick, they haven't suffered any of the qualifying reasons to get the unemployment, then I don't think they'd be entitled to it.
Okay. Sort of on the same note, for employees who have another health condition and are advised to self-isolate during the COVID-19 due to being a at-risk population, and this lasts for 2 weeks, they are only paid for 80 hours. That's still correct?
For the paid sick leave law, yes, they would be subject to that cap for the qualifying reasons under the paid sick leave law. And
on that same topic, if someone takes leave because they are exhibiting symptoms, but their tests turn out negative for COVID-19, will these rules still apply?
Well, I mean, again, whether they would be entitled to additional leave under the employer's existing policies or under the FMLA depends on, or even the ADA depends on exactly why they are taking the leave. If it's a qualified, disability under the ADA or a qualified, triggering event under the FMLA, that's going to be a case-by-case business. But if we're just looking at the FFCRA, if they were advised to seek a diagnosis, for example, let's say they had a sniffly nose or a fever or cough or something, and they went to go get tested, and they would be entitled to leave to go get the test and seek the medical diagnosis. But once the diagnosis comes back negative, theoretically they would no longer be entitled to that type of leave.
And I'll just jump in that I've actually had talked with a client who's dealt with this, where employees are really concerned about coming to work, or they think they have symptoms, or they think they have COVID-19, and it's understandable. There's a lot of concern and fear out there during these unusual times. But to be eligible for the paid leave under the Act, the employee either has to have exhibiting symptoms, and the regulations spell out symptoms. I mean, and I don't have that list in front of me. It's like fever, There's specific symptoms in the regulations, and they're seeking a diagnosis. The day they go to get the diagnosis, that's qualifies for paid leave. But if the doctor doesn't say, okay, I think you need to stay home, you need to self-isolate. If the employee is making that decision on his or her own, then it is that time out does not qualify for the FFCRA paid leave, the paid sick leave. And therefore, if you do provide paid leave, you can't claim the tax credit.
Okay.
And, just to add one thing, just to kind of, to everybody to have in the back of their minds, we're talking about the FFCRA, we're talking about FMLA. There's one thing that, employers do need to have back in their minds, and those are OSHA laws, the duty to provide a safe workplace. What does that mean? Especially in light of COVID-19, if employee starts raising concerns, I think, might be worth picking up the phone and, calling one of your attorneys just to kind of go over that situation with them.
A question that came up, the information that you provided today, is that only apply to private employers, or does that also include government and nonprofits as well, employers?
I mean, it applies to certain governmental and nonprofits. The PPP loans apply, for example, to certain nonprofits. And Charles, I don't know, that's something that has been a little murky as to what nonprofits. I mean, the act or the regulations specify 501c3s. I don't know if you have any thoughts on that.
Yeah, I mean, it is limited to 501c3s. So and also there's a veterans organization, 501c19, that is allowed. But there are lots of tax exempt organizations that may think that they're nonprofits on any other day of the week, but when it comes to looking at the CARES Act and the PPP, they're excluded from that definition.
Okay, one more, and I know we're running out of time, but I think it's important. In the facts at a glance that were issued on Tuesday, number 2 addressed a carve-out from the definition of small business where companies with over 500 employees could qualify under the PPP loan program. The FAQ specifically referenced the PPP program and did not mention the EIDL program. And the section was referenced noted that the definition of a small business applied under the 7A and the 504 programs. Does this mean that for the EIDL loan program, a company could not rely on this expanded definition of small business as set forth in the FAQ number 2?
Right. So the thing to keep in mind is that the EIDL and the PPP are entirely separate programs. And so that FAQ that the person's referencing there is answering questions within the context of the PPP program. So really nothing in that answer should be relied upon for the EIDL, specifically. However, the alternative size standard that they're referring to there, the SBA has industry size standards, which depending on your industry, usually it's measured by employee headcount, could be measured by average annual revenues. And then there's a separate alternative size standard, which says that if the tangible net worth of your business is $15 million or less, and George, correct me if I'm wrong, but I believe it's $5 million in revenue for the past 2 or 3 years. It's something like that. That's an alternative size standard if you have more employees than your industry size standard. So that's another way to qualify. Is that right?
That's right. I think it's 15 million.
Yeah.
But yeah, there is if you look in the FAQ, the person who just asked the question that they're referencing, it's in the FAQ question 2. That is an alternative size standard. So there's the standard that was amended, that the CARES Act amended, 500 employees or less. And then there's the standard expressed in the NAICS codes and the SBA regs, and then there is the third that I'm aware of, alternate size standard that Charlie just talked about.
Great. Well, sorry we went over about 4 minutes, but I want to thank each of you for taking time to share this. I want to note the folks that are watching with us, they will be back again on Tuesday evening at 6 p.m. If you know a business or community leader that missed today's session, please encourage them to register and participate on Tuesday evening at 6 p.m. Just wanted to note that next Friday, our webinar session will be led by Stephanie Keener, who will focus on how your businesses can stay in touch with your customers during the COVID-19 without getting lost in the crowd. So I hope you can join us. Thanks again. We will be sharing the slides with our audience. And if you want to see this webinar, we will be posting it up on the Virginia Community Capital's Facebook page in a little later this afternoon. But thank you. Happy Easter, everyone, and have a great day. Thank you.
Thank you.